Hello and welcome to the Sidebar, presented by True Crime News, taking you inside the courtrooms of high-profile and notorious cases from across the country. I'm your host, Joshua Ritter. I'm a criminal defense lawyer based in Los Angeles and previously an LA County prosecutor for nearly a decade. You can find me on all social apps at Joshua Ritter ESQ or at joshuaritter.com. We are recording this on Wednesday, June 18th, 2025. In this week's episode, a new trial for a man convicted of murdering his entire family when he was just a teenager. Plus, explosive evidence in the sex trafficking trial of Sean Diddy Combs. But first, deliberations in Karen Reed's retrial, as jurors indicate they could be acquitting the woman of the most serious charge. Today, we're joined by Marie Pereira, a lawyer, registered nurse, and legal analyst you can catch on News Nation, Fox, Court TV, and many other outlets. Marie, welcome back.
Thank you for having me. I'm so excited to be here.
I'm very excited to have you. I watch you all the time. I know that you follow these cases closely, and I always appreciate your insights. And especially on the one that we're about to jump in first, this is a case that has been kind of dominating the headlines and the true crime sphere for a while now. This is out of Dedham, Massachusetts, where after 3 days of deliberation in Karen Reed's retrial, jurors have not yet rendered a verdict, but some of their questions to the judge could indicate which way they are leaning. Judge Beverly Cannoni was asked for clarification about the drunk driving charges facing Reed, her media interviews, and the verdict slip to deliver their ultimate decision. Prosecutors who accuse Reed of drunkenly hitting her boyfriend, John O'Keefe, with her SUV before leaving him to die in the snow, featured Reed's media interviews heavily in their presentation during the retrial. This addition apparently confused some of the jurors who asked the judge if the interviews were considered evidence, which Judge Cannoni confirmed they were. They also had questions regarding the operating under the influence charge. Significantly, whether it pertained to Reed leaving the scene around 12 a.m., where O'Keefe was later found dead, or at the time she discovered the body at 5 a.m. To this, Judge Cannoni did not deliver a specific timeline, telling the jurors it's only you who decides the facts in this case. That's the answer to that question. You are the fact finders. Most impactful to a potential verdict, jurors also asked Cannoni, quote, if we find not guilty on two charges, but can't agree on one charge, is it a hung jury on all three charges or just one charge? Cannoni refused to answer the question, instructing jurors that they are not allowed to consider the consequence of their verdict. Those who watched the trial the first time around are likely experiencing deja vu with the verdict, as the case ended in a mistrial, but it was later revealed that jurors had voted to acquit on the most serious charge of murder while hanging on only the less serious charge of manslaughter. Wow, Marie, a lot going on here. It does seem like deja vu. My first question to you is, well, first of all, let's just get your reaction. What do you think the jurors are thinking? What do you think is possibly going on right now?
I think they're leaning towards an acquittal. And I'm saying that because of the question that they sent back to the court. If we are, and I'm paraphrasing, choosing not guilty on one, does it mean we're hung on the rest? I don't know how more clear they can make it to the judge that they're having problems understanding that it's not all or nothing. There can be a partial verdict. They're thinking if they choose one, it spoils the entire thing. She needed to explain that to them back then and now, and she's still not doing it correctly.
To that point, and this is a little nuanced, but her explanation was that they were asking her a question that was in the hypothetical form. In other words, if we are X, then what happens? And her position is, I cannot answer hypothetical questions, which I understand from a legal perspective. But do you think that was a mistake on her part, not to just explain to them essentially what you just did on how this all works?
I think it was a mistake, and I don't think the question was hypothetical at all. They said what they said. You don't have to tell them where to lean, but just answer the question. No, if you choose not guilty on one, it doesn't mean you're hung on everything else. They just want an answer. And I don't know why she's being so reluctant to give them an answer.
I don't know either. The answers that she's giving from the bench at least seem to indicate that she feels that her hands are tied legally. But many people are pushing back on that, including the defense, saying, "Hey, much similar to what you're saying, this isn't about hypotheticals. This is just about explaining to them the law and how it works." For a moment here, though. Some people believe that this is an indication that they may be in exactly the same spot that the jurors were last time, that they may have acquitted her of the kind of more serious charge of murder. I don't think we would be getting questions like this if they were hung on murder, but that they may be deadlocked on perhaps like a manslaughter, like apparently they were last time, now that we have these new revelations from the jurors after the fact. What do you think prosecutors do if this is another hung jury, the way that we saw it last time, or they only walk away with a hung jury and that OUI charge? What do they do now? Do you think they pursue this again? Do you think it's time to kind of call it a day? What are your thoughts?
I would say to call it a day, but again, a man's life was taken. So if they call it a day, what happens with that? Where is justice for John O'Keefe and his family? I think they would need to sit down with the family, maybe offer her some type of a deal and see if she would take the deal. Because at the end of the day, there was risk every time you go to trial. You know this from being a prosecutor and a criminal defense attorney. Sometimes you have to do a cost-benefit analysis and say, you know what? Maybe I should take a plea if one is offered, or maybe we shouldn't try this again because it's getting a little ridiculous. That would be the third time. It would show them that there's something wrong with the evidence you're presenting. There's something wrong with your ability to prove your case beyond a reasonable doubt. At one point, shut it down. But her family would need to speak to her if there is a plea offered. And more importantly, John O'Keefe's family would have to be a part of that decision making from the prosecutor's side, because he's dead. And who would be held responsible?
Yeah. No, excellent point. Many times what gets lost in all of this is the fact that somebody did lose their life. And John O'Keefe sounds like he was in a pretty amazing guy.
Yeah.
To that point, I think that one of the other things that they will have to consider, the prosecution, I mean, if they do think about even bringing this for a third time, is our case going to change at all? You know, many times prosecutors can say, well, listen, a witness was unavailable to me, or certain evidence wasn't allowed in, and I think that was a mistake by the judge. And you can see an argument where they will say, the trial we can put on again will be better than the one that we just did. I feel like this was the best shot the Commonwealth had. I feel like they put on a very admirable case of their case, and this is just about as good as it's going to get. If, with all of that in mind, what do you think a potential deal would look like? What do you think, in other words, Karen Reed's team's going to want before they accept anything? Or is it nothing, that they'll never accept any kind of responsibility? Could be that.
I don't think they ever will. With the level of confidence, the attorneys on her side, they're like superstars. There are people with T-shirts out there that are saying the dream team, and they're saying it was a frame up. I think Alan Jackson would never come back and take any type of a plea. So either they would have to do it again or drop the charges. And I think faced with doing it again or dropping the charges, the prosecutors would do it again. They're not going to just drop the charges and say, bye, Karen, have a nice day. That's not going to happen. And I agree with you. This was a fantastic representation of the prosecutor's case this time around. They used different witnesses. They didn't bring on certain witnesses. They did a great job, but you can't undo the facts. And again, you know this. Bad facts are bad facts. The investigation was shoddy. The motivation to lie was there on the part of the police. There were a lot of witnesses who came in, and it just showed that there had to be some type of corruption. As far as the experts, it was a battle of the experts, and I think they balanced each other out. The witnesses who came in for prosecution, most of them were John O'Keefe's friends. And it was the same thing. Did she say, I did it, I did it? Yes, but you didn't say it at the grand jury. The EMS guy who came in, she said, I did it, I did it. But you said nothing to the police right there, and the murderer is sitting right next to you. All of that doesn't change. I feel sorry for the jury because it's really very hard as I speak to you today. If I was on the jury to come up to say guilty or not guilty. But when that happens, you know who that favors? The defense. If you're not sure, it's a defense verdict.
You're 100% right. That is the way our system works. Beyond a reasonable doubt is a very high burden, and purposefully so. So you're right. It may just come down to they don't know, or they don't know enough, and that is enough for an acquittal. We shall see. They are continuing to deliberate as we are recording this. We may have a verdict by the time this is released, but we will continue to keep watching it closely. Let's move to Elk View, West Virginia, where a teen convicted of murdering his family will get a new trial after an appeals court ruling. Gavin Smith was convicted of 3 counts of first-degree murder and 1 count of second-degree murder for the slayings of his mother, stepfather, and 2 younger brothers. Smith was just 16 when prosecutors say he fatally shot Risa Mae Saunders, Daniel Dale Long, Gage Ripley, and Jamison Long. At trial, Smith didn't deny the killings. Instead, his defense centered on the argument that he didn't possess the requisite intent for first-degree murder. Ultimately, the jury saw it differently. However, a high court overturned the conviction after a reversible error by the trial judge in a ruling that will now grant the 21-year-old Smith another trial. Smith's defense successfully argued that an improper jury instruction indicating Smith could be paroled after 15 years prejudiced jurors who may have otherwise had reservations about sending a minor to prison for the rest of his life. While Smith has not received a court date for a new trial, we will continue to keep you updated as this case moves forward. Really interesting situation here, Marie, that we don't see all that often. Usually it's some sort of ruling on evidence that causes trouble on appeal. Here it was an issue with instructions that the jurors became aware that there was a possibility, according somehow, that he may be sentenced to less than life. And the thinking was that may have given jurors kind of taken them off the hook, as it were, taken the pressure off of them that they're going to send this young man away for the rest of their life, and that may have pushed them towards a verdict. Very interesting thinking by the Court of Appeal there. What are your thoughts?
Very good lawyering by the appellate attorney. I don't know how sentencing would ever make it to jury instructions. It's the judge who gives the jury instructions. And before that, the 2 sides hammer it out with the judge to say what they think he should say or what she should say. How did it ever come into play that, well, if he's found guilty, there's a possibility of parole? Sentencing should never be a consideration any juror has in their mind during deliberations. They tell you, don't pick for the defendant, don't be compassionate, just follow the law and be as neutral as you can. So the fact that sentencing was ever brought up, I agree with his attorney, the appellate attorney, because that would sort of take it off the jurors and say, you know what, he's only 16. Let's just find him guilty. He'll be held accountable, but he'll be eligible for parole in 15 years. So it's not so bad. They never were supposed to take that into consideration. So the higher court made the right decision to vacate that and give him another chance. I don't know if it's going to come out differently, because really he didn't deny what he did, because it's my understanding he never took the stand. They argued he didn't have the mens rea for murder in the first degree, that he had impulse control issues, so he wasn't able to formulate the necessary mens rea for that first degree murder charge. That's not, I didn't do it. That's just good lawyering. Let's see this time around, will he explain himself as to what happened, why he did it? Was there any defense at all?
Yeah. You touched on this, but explain to listeners why it is that jurors shouldn't know about potential punishments, sentencing, and why they shouldn't consider that. Because many times people go into jury selection never experiencing a trial before, and they think they might play some role in that. They think that, hey, if I'm going to be asked to decide the guilt or innocence of a person, I want to know and maybe even have a say in what happens to them. Tell us why it's important that they don't.
Because a person has the right to be presumed innocent, not guilty, before a trial. Because at the end of the trial, there is usually a sentencing phase, whether it's the judge or a case where the jurors decide what the sentence should be. They separate the two. Guilt should not be premised on emotion, compassion. It should be premised on whether or not the prosecutors proved each and every element of the crime beyond a reasonable doubt. And that's that. It shouldn't have anything to do with your compassion, your regret, how much time the person is going to serve. One should not be mixed with the other. That's why we have sentencing phases.
Extremely well put, Marie. Thank you for that. Let's finally move on to our latest case here out of Manhattan, New York, where jurors were shown explicit videos of freak-offs in the federal sex trafficking trial of Sean Diddy Combs after the trial judge issued a stern warning to attorneys for both sides. Judge Arun Subramanian didn't mince words over the alleged leak of privileged information to the media, threatening both prosecutors and the defense with sanctions for any further infractions of the gag order, telling attorneys, quote, "The buck stops with you." This came after Monday's dismissal of a juror due to questions of his credibility and statements regarding his residency. As the proceedings became increasingly heated this week, Combs' defense entered explosive video evidence of Combs' alleged freak-offs. Jurors watched nearly 10 minutes of footage on private monitors while listening to the audio through headphones in an effort to keep the evidence private. Additional bombshells could be forthcoming as prosecutors are expected to wrap their case by the time you're listening to this episode, and we will keep you updated as Diddy's defense presents what they've indicated will be a very short case. First, I got to ask this. We've all been anticipating these freak-off videos being played. We knew that it was going to be salacious and it was going to be shocking to the jurors. And it was always a question of not if, but when the prosecution would play them. Now they've decided to play these clips at the end of, or close to the end of their case. What do you think about that from a strategic perspective?
You know what they say in law school, primacy and recency. If they played it last, it's going to be the last thing that the jurors see. And I would imagine that they cherry picked the pieces that they wanted to play. And maybe they tried to play pieces where the people engaging in the intimate acts didn't look so happy. Because I would imagine if they're saying that all of it was forced through lack of consent perhaps obtained by drugging the person, forcing them to take chemicals to alter their mind state. Maybe the pieces they cherry pick, and I say the prosecutors, showed someone who looked like they were half drugged out and doped up under the influence, and that would negate any kind of consent, and it would support the testimony of the women who said, he made me take Molly, or he made me take ecstasy, I didn't want to. It's necessary to prove your case. As salacious and painful as it is to both the people who are on the video and the poor jurors who may have never watched any type of porn in their lives and they're being forced to watch it as part of this case. It's a tough decision, but I would think they did it strategically to make the jurors remember this is what happened here.
I agree. I mean, that is a really always a interesting choice for the prosecution. What do they start out with? You know that they want to kind of kick off their case with something strong, and what do they end with? And here they started off with Cassie early on. She was a very strong witness, and now they've ended with these videotapes, which we can't watch them, we can't see them, but it seems like the reaction from the jurors is that they are very impactful. To your point, though, you were talking about it sounds like what they picked were carefully curated clips to show people who may not have been consenting. The defense didn't hide from these. They actually leaned into it and, in fact, played longer clips for the jurors. What we're being told is that the clips played by the prosecution were sometimes a few seconds or minutes long, whereas the clips being played by the defense were sometimes 5 minutes or more long. And with that idea of showing, hey, the context matters here, and that these people look as though they are willing participants in these activities. Do you think that was a sound strategy by the defense?
Absolutely, because if prosecution brought it up, you can't just act like it didn't happen, because this is the whole crux of the case. Fun fact, I was in New York last week, and I was able to go to the Sean Diddy Combs trial, and I got into the overflow room, and I was able to watch one of the witnesses, Jane, testify, not live, but on a big screen in the courtroom with a bunch of other people. And I could tell you, prosecution put a good case out when they put her on the stand, because she said, I didn't want to do it. I didn't enjoy it. I faked all my orgasms, and I said, no, I don't want to. And they had text messages where she's saying, I'm so tired, I'm on my menstruation. And she even sent like a picture of her bloody tampon to show how tired she was, and she couldn't engage. She didn't call them freak offs. She said hotel dates.
Hotel nights.
Hotel nights, correct. And so, leading back to your question, prosecution also defense also on cross-examination asked her, did you ever tell anyone you didn't enjoy the hotel nights? Did you ever show anyone the injuries you claimed you received prior to one particular night? She said she had a big knot on her head. He punched her. He said, go get that escort, get in the car, go get him from the driveway, get dressed, and go have intimate relations. And he didn't use those words. And go have, oral situation. Do it now, get dressed. So he wants, the defense wants to play the whole thing to show whoever it was engaged in the act at a clip, a second, where they're enjoying it. And it doesn't look like anybody's faking an orgasm. It looks like two people getting their freak on willingly. Nobody looks drowsy. So you have to play the whole thing, not cherry pick. So I'm not surprised that defense's clip could be longer than the prosecution, because the prosecution was probably there second to second looking for somebody looking like this, and the defense is looking for this. That's what's going on here.
I like that. For those listening on audio only, do yourself a favor and watch the video so you get exactly what Marie is saying.
Exactly.
But I think you're absolutely right.
Have it all.
They're obviously not watching video where people are screaming, I do not give consent. Nor are they watching video of people saying, I give consent. It really all has to do with the surrounding circumstances and how would a reasonable person perceive all of that. And you're right. It could, 1 second, it could look bad, and the next second, it could look very different. So to that point, where things stand now, I know this case isn't over, but do you feel that the prosecution has made their case here, or do you think that they still have a ways to go?
I think they still have a ways to go. And I was thinking to myself, they need to, in the interest of primacy and recency, if it was possible, to bring back the psychotherapist they brought in the beginning to explain trauma bonding, and to explain why a person who's being subject to all of this abuse and being forced to engage in intimate acts with escorts when they never wanted to, why would they stay? I think they need to leave the jurors with that because it was so long ago. They need to hear it again because that's the biggest problem they have, proving that these people engaged in the freak offs and hotel nights without proper consent, that it was coercion. It was basically human trafficking, sex trafficking. That's the problem. So they maybe need to bring somebody to just refocus the jurors. Okay, I know it looks bad, but these people were psychologically traumatized. And that's what you're seeing in the sections where the defense is playing ow when it really wasn't that way at all.
Yeah. It is certainly a fascinating case, and it looks like it should be coming to an end within the next few days here, and maybe we'll even be talking about a deliberating jury next week. But Marie, as always, it's been an absolute pleasure. I always enjoy our conversations. Before I let you go, tell us, where can people find out more about you? Do you have social media or other spots they can check you out?
Yes, I do. I have an Instagram. It's the Marie Pereira, my full name. I think it's Instagram, TikTok, and Facebook. I'm also an immigration activist, and I have an Instagram. It's Haiti Immigration Project. On there, I put on my volunteer cap, and I do free work permits for migrants and those who qualify for TPS. I assist them with their applications. And I'm following in your footsteps, and I have a YouTube channel, and it's called, it's brand new with a few clips, videos, and it's Legal Analyst Unscripted. Because I always have a lot to say. Some of what I say, we don't allow on the regular channels. So I get to really, really speak my mind. And it's not just, I describe a little.
Fantastic. So keep the kids in the other room and check out Marie's new channel. Thank you so much again. I'm your host, Josh Ritter. You can find me on Instagram and Twitter at Joshua Ritter ESQ. And if you want to hear my thoughts and coverage on even more true crime cases, you can also check out my brand new YouTube channel, Courtroom Confidential. And of course, you can find all of our Sidebar episodes wherever you get your podcasts. And we want to hear from you. If you've got questions or comments you'd like us to address, please tweet us your questions with the hashtag TCN Sidebar. And thank you for joining us at the True Crime News Sidebar.